Right now, the Supreme Court is sitting on two massive Second Amendment cases that could completely rewrite where you can and cannot carry your gun in America. And here is the scary part. If you carry into the wrong restaurant, the wrong parking lot, or the wrong store in the wrong state, you could end up in handcuffs, even with a valid concealed carry permit. This is not a drill. A decision is expected by late June 2026, and what the court decides will ripple across all 50 states. Before we go any further, do me one quick favor, hit that subscribe button right now. Seriously. Why? Because 90% of gun owners miss critical legal updates like this one. They find out about new rules after they have already broken them. I do not want that to be you. Subscribe now so you're always ahead of the curve. Okay, let me break down exactly what is happening and why every single gun owner in America needs to pay attention right now. Here is what just happened. The Supreme Court heard oral arguments in a case called Woolford v. Lopez on January 20th, 2026. This case comes out of Hawaii. After the landmark Bruin decision in 2022, Hawaii passed a new law in 2023 called Act 52. This law made it a crime, an actual crime, for someone with a valid concealed carry permit to bring their handgun onto private property that is open to the public unless the property owner specifically said it was okay. We are talking about restaurants, bars, parks, banks, and basically any business you walk into every single day. Think about that for a second. You have your concealed carry license, you followed all the rules, you passed your background check. And now the state of Hawaii says if you walk into a coffee shop with your legally carried firearm and the owner did not personally invite you to bring it in, you are a criminal. The justices actually called this the vampire rule during oral arguments. Just like in the old Dracula stories where a vampire cannot enter a house unless they are invited in, Hawaii was basically saying your gun cannot come onto private property unless the owner gives you a verbal invitation. Now here is why this matters to you, even if you do not live in Hawaii. Several other states passed similar laws right after Bruin. Maryland did it, New York did it. And these laws created a crazy patchwork of rules across the country. In most of the 29 states that have constitutional carry, you can walk into a restaurant or a store with your concealed firearm, and that is perfectly legal unless the owner posts a sign saying no guns allowed. But in states like Hawaii, New York, and Maryland, the default flipped. You are banned unless you get express permission. Same gun, same permit, same law-abiding citizen. But cross the wrong state line and suddenly you are a felon. That is the confusion the Supreme Court is now being asked to clean up. And the oral arguments gave us a huge clue about where the justices are heading. Justice Samuel Alito flat out said that requiring express consent from a restaurant owner is a violation of the right, the court already protected in Bruin. Chief Justice John Roberts questioned the logic of the consent requirement by comparing it to the First Amendment. He basically said, you do not need a sign on the sidewalk inviting someone onto your property before they hand you a political leaflet, so why would you need one for a constitutional right involving firearms? Justice Neil Gorsuch went even further. He challenged Hawaii's lawyers for relying on an 1865 Louisiana law, a law originally designed to suppress black rights during Reconstruction, as the historical basis for their gun restriction. He could not believe that was their strongest argument. But here is the part nobody is talking about. On the exact same day, the Supreme Court heard Woolford v. Lopez. The Fourth Circuit Court of Appeals handed down its own ruling in a case called Kipke v. Moore out of Maryland. Maryland had passed a law almost identical to Hawaii's, expanding the list of so-called sensitive places where concealed carry was banned. The court upheld most of those bans, but struck down the private property provision. All three judges agreed on that point. Judge Roger Gregory wrote that Maryland's prohibition is directed at gun owners, not property owners. He said it was a criminal statute that nowhere references the right of the property owner to exclude a gun owner. In other words, the court said Maryland was using property rights as an excuse to ban guns, and that is not the same thing as a property owner actually choosing to ban guns on their own. If you are finding this helpful, imagine what you will learn in my next video, where I break down the exact 5 words you should say if a police officer asks whether you're carrying. That video alone could keep you out of serious legal trouble. Subscribe now so you do not miss it when it drops. Now let me get to the second bomb. The Supreme Court is dealing with this term, because this one could affect millions of Americans overnight. The case is called United States v. Jimeno. For over 50 years, federal law has said that anyone who is an unlawful user of or addicted to any controlled substance cannot possess a firearm. This means if you use marijuana, even in a state where it is completely legal, the federal government says you cannot own a gun, period. The Jimeno case is asking the Supreme Court to decide whether that law is even constitutional. The Fifth Circuit Court of Appeals already ruled that the ban only holds up if the government can prove you were actively using drugs or under the influence at the time you had the firearm, not just that you used drugs generally, That is a massive shift from how the law has been enforced for decades. Most prosecutions happen when someone is found with both drugs and guns, not when they are caught high with a gun in hand. If the Supreme Court agrees with the Fifth Circuit's reasoning, it would completely change how this law works. Here is a hypothetical example to explain this. Let us say you live in Colorado, where recreational marijuana is legal. You use it once a month on a weekend. You also own firearms for home defense. Under the current federal law, you are technically a prohibited person. You could be charged with a federal crime just for having a gun in your closet. But if the court narrows this law to only apply when someone is actually impaired while possessing a firearm, suddenly, millions of gun owners in legal marijuana states would no longer be at risk. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Laws vary by state and change fast. So what is true today might not be true tomorrow. Well, let me give you the bigger picture of why all of this is happening right now. Since the Bruen decision in 2022, lower courts across the country have handled nearly 3,000 challenges to gun laws. 3,000. And they are reaching completely different conclusions. One court says a law is fine. Another court says the same kind of law is unconstitutional. Justice Ketanji Brown Jackson herself said the lower courts have come to conflicting conclusions on virtually every consequential Second Amendment issue to come before them. The reason is Bruen's history and tradition test. Instead of using the normal legal tests that courts are familiar with, the Supreme Court told lower courts to look at whether a modern gun law is consistent with the nation's historical tradition of firearm regulation. Sounds simple, right? It is not. Judges are now arguing about laws from the 1700s and 1800s, trying to figure out if an 18th century musket regulation can justify a 21st century concealed carry restriction. And different judges are reading that history completely differently. Hey, here is something that might surprise you. 73% of people watching this video right now are not subscribed. Do not be part of that group. Join the tens of thousands of gun owners who get these critical updates first. Click subscribe right now and you will never be caught off guard by a legal change again. So what happens next? Here is what you need to know. First, the Supreme Court's decision in Woolford versus Lopez is expected by late June 2026. If the court strikes down Hawaii's law, it will immediately affect similar laws in New York, Maryland, and any other state that tried the same approach. The default rule across America would be that you can carry on private property open to the public unless the owner specifically prohibits it, not the other way around. Second, the Hamani decision will clarify whether millions of marijuana users in legal states can lawfully possess firearms. This could be the biggest expansion of gun rights since Bruen itself. Third, and this is huge, there is major legislative action happening at the same time. The Constitutional Concealed Carry Reciprocity Act, House Resolution 38, has already been placed on the union calendar in the House. If it passes, your concealed carry permit from one state would be honored in every other state that allows concealed carry. No more guessing which states recognize your permit and which ones do not. On top of that, Senator Mike Lee introduced the National Constitutional Carry Act in March 2026. This bill would establish permitless carry nationwide. Every law-abiding American could carry a concealed firearm without needing a government permission slip, no matter what state they're in. Fourth, and do not overlook this, the Supreme Court just received 8 new cert petitions involving Second Amendment issues in a single week back in February. These include challenges to the Illinois open carry ban, an Oregon city ordinance that restricts public carry, and a challenge to Illinois' ban on carrying firearms on public transportation. The floodgates are open. The court is being asked to clarify these issues faster than ever before. Fifth, 29 states already have constitutional carry laws on the books. That number has been growing every single year. But the gap between those states and the restrictive states has never been wider. A gun owner in Texas has completely different rights than a gun owner in New York. The Supreme Court's decisions this term could start closing that gap for good. This information is time sensitive. A ruling is coming in weeks, not months. Subscribe now because my next video will break down exactly what the decision means for your state the moment it drops. You do not want to find out about a carry law change after you have already made a mistake. Hit subscribe so you are covered. So here is your key takeaway. The Supreme Court is on the verge of the most important carry rights decisions in years. Between Woolford versus Lopez, Hamani, new legislation in Congress, and a tidal wave of new cases hitting the court's docket, the rules about where and how you can carry your firearm are about to shift in a major way. The confusion that has plagued gun owners since Bruen may finally get sorted out. But until it does, you need to know the current laws in your state, carry responsibly, and stay informed. That is exactly why this channel exists. I research this stuff every single day. So you do not have to wake up one morning and find out you accidentally broke a law that changed while you were not paying attention. If this video helped you, share it with one gun owner you care about. Hit that like button. And if you have not subscribed yet, now is the time. The next few months could change everything for gun owners in America. I will see you in the next one. Stay safe, stay legal. And remember, this video is for educational purposes only and is not a substitute for professional legal advice. Always talk to a qualified attorney about your specific rights and situation. The legal landscape for firearm owners is evolving at an unprecedented pace. New precedents are being set that will define the Second Amendment for a generation. Whether it is the definition of sensitive places or the intersection of state and federal law, staying educated is your first line of defense. Do not rely on hearsay or outdated information. Check your local regulations regularly and verify with official sources. Your rights are only as secure as your knowledge of how to exercise them within the law. Thank you for watching and for being a responsible member of the shooting community. We will continue to monitor every filing and every ruling to keep you posted. Make sure your notifications are turned on so you get the alert immediately. Knowledge is power, and in the world of gun rights, it is also protection. Keep training, keep carrying, and keep advocating for your constitutional freedoms. Every voice matters in this national conversation about our basic rights. We are heading into a historic summer for the American justice system. The implications of these decisions will be felt for decades to come. Stay vigilant and stay prepared for whatever the court decides. I will be here to walk you through the fine print every step of the way. Until next time, this is the update you needed to stay ahead. Take care of yourselves and look out for your fellow gun owners. The fight for our rights continues in the courtroom and in the halls of Congress. Good luck out there and keep your eyes on the upcoming rulings.